Good evening, ladies and gentlemen. I'm Greg Joseph, President of the Supreme Court Historical Society, and I'm delighted to welcome you this evening to the Society's celebration of the 30th anniversary of the first term of Justice Sandra Day O'Connor on the U.S. Supreme Court. We are deeply honored to have with us this evening Justice O'Connor, Justice Ruth Bader Ginsburg, Justice Sonia Sotomayor, and Justice Elena Kagan. This is the first time the four of them have joined together for a public program, and we are extremely grateful that they've done so this evening to join in this celebration. We also want to thank Jim Duff, the CEO of the Freedom Forum and the Freedom Forum, for making this magnificent space available to us at the Newseum this evening. Jim, long prior to his being CEO at Freedom Forum, has a history with the Supreme Court Historical Society dating back to his time as Administrative Assistant to Chief Justice Rehnquist, and before that, Chief Justice Berger. I also want to thank Society President Emeritus Frank Jones for his generous donation to help support the events this evening. Frank was a distinguished president from 2002 to 2008, and only because of illness isn't with us this evening. Our panel this evening consists of the four women who, to date, have served on the United States Supreme Court. Even to summarize each of their careers with highlights would take far too long, so I'll be very brief. Justice Sandra Day O'Connor was nominated to the court by President Ronald Reagan on July 7, 1981, and she was confirmed by the Senate on September 22, 1981, to succeed Justice Potter Stewart. She served for the next 24 years, and she retired on January 31, 2006. Justice Ruth Bader Ginsburg was appointed to the court by President William Clinton on June 14, 1993, and she was appointed and confirmed by the Senate and assumed her role on August 10, 1993. Justice Sonia Sotomayor was appointed by President Barack Obama on May 26, 2009, and assumed her position on August 8, 2009. In the following year, Justice Elena Kagan was appointed to the court by President Barack Obama on May 10, 2010, and assumed her position on August 7, 2010. We are honored and grateful to bring all of them together to celebrate the 30th anniversary of the groundbreaking tenure, as it began, of Justice Sandra Day O'Connor. I'd ask everyone to turn off cell phones and BlackBerries, and with that, I'm going to turn the program over to Jim Duff. Thanks very much, Jim.
Thank you very much, Greg. We're delighted that the Supreme Court Historical Society is having this celebration of Justice O'Connor's 30th anniversary of her appointment to the Supreme Court here in the Annenberg Theater at the Newseum. We're very honored you're here with us this evening, Justice O'Connor, and we're also very, very pleased and honored that Justices Ginsburg, Sotomayor, and Justice Kagan are here with us on a very special night. It's all the more special because it's the 4th anniversary of the opening of the Newseum, so we couldn't have done better to celebrate that, I would say. We don't have a quorum, but we have enough to grant cert here tonight. I don't know if there's anything you might want to consider, but we'll move on to some softer questions, I think. Justice O'Connor, your nomination as the first woman to serve on the Supreme Court of the United States 30 years ago was certainly historic. It was also a very closely guarded secret. William French Smith writes in his memoirs that of hiding you and a clandestine meeting at DuPont Circle in front of a drugstore.
Well, he wanted to get me down to the White House to meet with the president. He had asked me to come back here and meet with some of the president's close advisors, which I did, and he had rented hotel space someplace downtown so that we could meet that day, and members of his cabinet, several of them had come, and they were able to ask questions. And so then at the end of the day, he said, and the president would like to see you at the White House this afternoon. I'd never been to the White House. I had never seen it. I didn't know where it was. And I said, well, where is it? And he said, well, I can explain it to you, but he said, I'll tell you what I'll do. I'll ask my secretary to pick you up. And she has an old green Chevrolet, and she'll pick you up on DuPont Circle if you're out there. I had a meeting at DuPont Circle of an organization to which I belong. So I went out on DuPont Circle and waited, and here came the old green car, and his secretary picked me up and drove me down to the White House. And we were admitted and made our way in due course to the Oval Office, and it's so small. I mean, it's such a shock to get in there. You think, oh my gosh, this is the White House, it's the president's office, and it's this tiny little oval place. So we sat down and talked, and it was very pleasant. He was a man very easy to talk to.
Yes, yes,
so
that's great.
That's how it all started.
These days we see lists emerge, and there's not so much secrecy around it. They're finalists. Do you think that's because it's just more difficult to keep a secret as to who's being considered, or is it just a different approach?
I've been touring the museum today. They can tell you, I don't think you can keep any secrets in Washington myself. I think that's impossible.
Was it a goal of yours to become a justice?
Oh, heavens no. Goodness, no, it certainly was not. And I wasn't sure what I ought to do, because it's all right to be the first to do something, but I didn't want to be the last woman on the Supreme Court.
Thank goodness for that.
If I took the job and did a lousy job, it would take a long time to get another one. So it made me very nervous about it.
Well, you paved the way for some great justices. When did you first think about it? Was it
when he sent Ken Starr and some other people out to Arizona to talk to me, and they wouldn't say what it was for, and so it could have been some cabinet post or something like that. They wouldn't tell me, and we had some nice visits, but they'd done a lot of homework out there. They'd gone through all my papers, and I had served in all 3 branches of Arizona's government, so I had a big paper trail they had to go through, I guess.
Who were your role models? Were there
for what?
For you were a trailblazer, so I guess you're the role model for everyone else, I suppose. Justice Ginsburg, where were you in your career when Justice O'Connor was appointed, and what did it have any special meaning for you at that point in your career?
It was a moment that one of those few in life that you remember exactly where you were and how you felt. I had been on the D.C. circuit for exactly 1 year, and I was driving home, turned on the news, and the news was,
oh, for heaven's sakes,
Sandra Day O'Connor. And I was about to cheer, but no one would hear me. And then I found out what I could about this great lady, including what good lunches she made when Ken Starr and whoever came with him visited her in Phoenix. And I read, well, I knew that she'd been the head of the Senate in Arizona and on a trial court, an intermediate appellate court, and you had been to a conference on federalism in William and Mary?
Yes, and I'd gone to a couple of those meetings with people from the British Isles, lawyers and judges. Remember those that Warren Burger initiated? I'd gone to a couple of those. But I certainly wasn't well known in the judicial community of the nation.
Justice Sotomayor, where were you in your career?
I was almost at the beginning. My second year after graduating from law school, 2 years after I graduated, in the DA's office in Manhattan. And I remember having conversations at lunchtime in that awful Yale cafeteria talking about how long it would take for a woman to be appointed to the Supreme Court.
Yeah.
And there were bets being taken whether it would happen in our lifetime or not. So the unlikelihood, or the fact that it was still something we weren't sure of, bespeaks how historic it became that only 2 years later Sandra was appointed.
What did it mean to you at that time in your career?
Well, in law school, there were no women on the Supreme Court. There was no woman on the Court of Appeals in my state, New York. Most large law firms that at the time were a few hundred lawyers, today there are thousands, but back then there were still a number of them that had no women lawyers whatsoever.
Right.
And so for us, in my time at law school, the doors were opening, but they were very, very small openings.
Yes.
And so the idea that this barrier had been reached so quickly was sort of an inspiration to think that more could come. Mm-hmm. And that certainly that opportunities for us would grow. And so they obviously have, because Ruth followed, took too long, but Elena and I followed shortly thereafter.
I mean, this is fabulous to have all these women on the court.
It was indeed.
But Ruth, I will say for President Reagan, when he was campaigning to be president, he didn't think he was doing too well with the female votes. And he started making statements about, if I'm elected president, I would like to put a woman, a qualified woman, on the Supreme Court. And he made enough of those statements that then, about 4 months after he had become president, Potter Stewart, Justice Stewart, retired. And there he was faced with what to do.
With what he said.
Yeah.
Well, he was a man of his word.
He was.
Justice Kagan, where were you in your career when Justice O'Connor was appointed?
Well, I was still 2 years shy of going to law school. Hate to rub it in, you know. But even I knew enough to be impressed. I had just graduated from college, actually, and I remember the announcement and thinking,
That's interesting.
What a stunning thing.
Did it have particular meaning to you? Had you thought at that time about going to law school and perhaps becoming a judge or justice?
You know, I was thinking about it. It was one of the things that I was mulling over. But I remember the announcement and feeling very, very inspired by it.
You clerked for Justice Marshall when Justice O'Connor was on the bench.
True.
And what was that? Was that of particular meaning to you? That Justice O'Connor
you know, she was a formidable person. Even a clerk knew how formidable Justice O'Connor was.
Oh, I hope not.
You're going to tell your joke about your cast?
Yes. About what?
The cast.
Oh, okay. Okay, here's my Justice O'Connor joke from when I was a clerk. So Justice O'Connor founded, one of Justice O'Connor's achievements on the court was she founded an exercise group.
Yes, indeed.
And she liked to have women clerks come to the exercise group.
Yeah.
And I failed to come to the exercise group.
I noticed.
Well, that's the story, in fact. I used to play basketball instead.
Yeah.
I used to play basketball.
Well,
I didn't go to the exercise group. And one day, I tore something in my leg playing basketball, and I was on crutches for a few weeks. And the day after this happened, I was on crutches. I was walking down the hallway, and Justice O'Connor was walking the other way. And she stopped, and she said, what happened? And I said, well, you know, I tore whatever I tore playing basketball. And she sadly shook her head, and she said, it wouldn't have happened in exercise class.
And I'm sure that's true.
Elena, I was a failure too, because Sandra encouraged me to attend the class, but it's at 8 o'clock in the morning. As everyone knows, I'm a night person.
I told her the same thing.
Yeah, I haven't done too well getting him to class. I still have my class,
I was going to
It's
ask
still
you.
going on, and I went this morning, as a matter of fact, at 8 a.m., and it was good. And that meant a lot to me, to have that class. That just really mattered. And all the years I was in Arizona, I had an early morning exercise class.
You were a trailblazer in many ways, and that exercise class at the Supreme Court was one of the first in that regard. What are you doing for exercise now?
I go to my exercise class. What do you mean?
Are you playing golf? You still play golf?
Yeah, once in a while. I'm not very good, and that's not much exercise, you know.
Yeah. It is for me. I do a lot of walking.
Oh.
But how do you enroll in that? Or maybe it's enlist. How do you enlist in your exercise?
See me. I'll get you in. I got Justice Breyer up there a few times, but he didn't want to be the only man up there. So if you'd join too, maybe we could get it going.
Good. President Reagan signed your nomination to the court on August 19th, 1981, and you were confirmed by the Senate on September 21st, 1981, by a vote of 99-0. You took your oath on September 25th, 1981. We've certainly seen remarkable changes in the appointment and confirmation process since then. Do you have any observations about the current state of the nomination process and what it's a little?
Well, it's less likely to be 99-0, I think. There seems to be a little more controversy than there was at that time. At the time I went on, I think it was expected that whoever was the incumbent president would fill a vacancy on the court, and if she didn't have horns and looked too frightening, they'd confirm the nomination. I think it's changed a little bit since then, I'm sorry to say.
And Justice Ginsburg, you had more recent experiences with it. Do you have any observations, and Justice Sotomayor and Justice Kagan too, do you have observations to make now about, now you're safe, you're on the court, you can
okay.
Observations to make about the process?
Well, it was a much different process for Sonia and Elena than it was for me, because I was the beneficiary of the Senate Judiciary Committee's embarrassment over the nomination of Justice Thomas, and they wanted to make sure that they were civil.
Yes,
they wanted to make sure that there were women on the Judiciary Committee. So my hearing, it was rather dull. And the vote wasn't 99, but it was close. Mm-hmm. It was 96-3. Mm-hmm. Mm-hmm. And Justice Breyer was also a beneficiary of that atmosphere. I mean, the Senate back in 1993 and 94 was truly bipartisan. Mm-hmm. Senator Hatch was, I think, my biggest supporter on the committee. So I wish we could get back to the way it was in those years.
What about your experience?
I think that what we've fallen prey to is the public's expectation that there are answers to every question. That a hearing's going to be a place where a prospective judge is going to say yay or nay to whatever social issue and outcome an individual member of the public believes in. And I think that so long as that expectation continues to be fed by both the pundits who examine our records for tea leaves about how we're going to vote in certain issues or not, that we're never going to satisfy anybody with the system as it currently exists. Because the reality is, if what you're attempting to do is to get clear answers to how we're going to rule on cases that are coming before the court, I think you better be suspicious if you have a nominee who says, this is the way I'm voting.
Right.
Because it will suggest that that person's coming in with a pre-made-up mind and an unwillingness to listen. Having said that, I at least found that my personal meetings with the senators were very civil, by and large. And to that extent, it was easier to deal with the sort of public grilling that I received, and knowing that it was each of us playing our role. for purposes that I wish were different, because it did become sort of role-playing in front of the cameras. But I don't know that we're going to be able to satisfy people so long as the expectation of what they're expecting from the process remains the same.
Justice Kagan, do you have?
Well, there's no doubt that the two of us experienced a different process from the two of you. I remember thinking at one point during the process, people were asking me what I thought of all the things that Justice Ginsburg had wrote. And I thought, I'm being asked as much about Justice Ginsburg as she was asked. And, you know, isn't there enough that I have to answer for? But, you know, I wish that there were more bipartisanship in the current process. But that said, I do agree with Justice Sotomayor that senators of both political parties, I felt, treated me fairly and respectfully. And it's just a shame that it's sort of come to a pass where people, Republicans, feel as though they can't vote for the nominees of Democratic presidents and vice versa.
This may be more of an issue with the appellate courts and the district courts, but do you think it would be helpful if the Senate imposed a rule on itself of a time frame to vote up or down on a nominee, rather than, because some of the appellate and district court nominees drag on for over a year in the nomination process?
I think you're right that it's a problem for the courts of appeals and the district courts. Sonia, you had experience with that. How many years between your nomination?
It was nothing, really, and I don't think Elena's was either. It was just a couple of months for both of us.
No, I mean for the Second Circuit.
Oh, for the Second Circuit, it was 22 months.
22,
yeah, that's it. Because if Supreme Court nominee, it's going to be short.
Right.
It's going to get top priority,
right,
and it will go through in a matter of weeks. But it is still the case, it's been the case for some time, that you can be nominated to a court of appeals and wait months, and in Sonia's case, 22 months.
I had 18 for the district court as well.
Wow.
So waits can be terribly long.
Well, if they would just put a time limit on themselves and then move, if you vote up or down and then move on, that would be helpful, it seems. Justice O'Connor, when you arrived at the court, I recall an atmosphere of civility on the court at that time. I think of Justice Powell and others, and it continues certainly to this day. In fact, I know Justice Thomas just spoke last week at the University of Kentucky, which won the National Basketball Championship just recently.
Oh, you noticed?
Yeah.
All right.
We got told just as we came in.
And he commented that he's never heard a harsh word or unkind words spoken in conference, the conference in which the 9 justices meet. How important is civility in the work of the court? And
well, I think it's vital. I mean, it's a small group of 9, and I think it's exceedingly important that everyone be polite and kind and pleasant to each other. I think that's vital. You have to disagree on the merits of things, but you can disagree agreeably. And I think that's very important, and the court does well on that score, I think.
How is it preserved when there's turnover on the court? I know, I think Claire Cushman, who's with the Historical Society, has written in her book, Court Watchers, that, for example, Justice Ginsburg, Justice White gave you his Chambers manual to assist you. Are there other ways in which...
I didn't know there was a manual. I never got one.
That's where all the secrets are.
Yeah, all the secrets. I'm finding out all these secrets.
Well, it was the internal operations within his chambers.
Oh, within his chambers.
He sent it to me.
Okay.
He sent it to me in the D.C. Circuit, and he said, don't open this until you're confirmed, but when you're confirmed, maybe it will be a little help.
Oh,
so
good.
My clerk's job every year is to update it, and I gave my manual to Sonia and to Elena when they came on board. So that was a tremendous help.
There's wonderful traditions at the court, and certainly civility in recent times has been a strong attribute of it. Do you think that the other branches of government should emulate it, or is that possible, or are they so different in structure and
they're different.
nature?
I mean, you just have 9 members on the court, so it's a small institution. And they live and work in quarters that cause them to see each other frequently. And I just think it's very, very important that the relations remain cordial and friendly and thoughtful. And I think they have. I think we're lucky.
There was a time when the Senate was known as a gentleman's club, when there was a great deal of cordiality. And that has gotten lost.
That's gone. But we mustn't let it go at the court.
If Justice Ginsburg will remember the other day when we were having this conversation about why there's more civility in more recent times on the court than perhaps in its earlier history. Do you remember what you said, Ruth? Perhaps she doesn't.
No.
She said, it's because we've had women for the last.
Well, my guess is that that's especially true of Justice O'Connor. You know, Justice Thomas once told me we have a tradition on the court where we eat lunch together after we hear arguments and after we have conference. So it ends up being 8 or 10 or 12 times a month. And Justice Thomas once told me that if ever he went a couple of days without going, Justice O'Connor would appear at his doorstep and say, Clarence, why aren't you there?
Lunchtime.
Lunchtime. And you encouraged everybody to participate in those kinds of communal activities.
Yes.
And I think that's very important.
I do too. Yeah.
Justice Ginsburg, was Justice O'Connor's presence on the bench of particular help to you when you joined the court?
Yes. My advisor, my big sister, she told me a little bit, just enough for me to get by in the early days. Then I came to her with a problem when the chief made assignments at the end of my first sitting. The legend was that the junior justice gets an easy, unanimous case. And I think it was true for you two.
Yeah, that's right.
But the old chief gave me a miserable ERISA case in which the court had divided 6-3.
Oh, yes.
So I went to Sandra, thinking that she would persuade her good friend, our chief, to revise the assignments. So I told her, and she said, Ruth, you just do it. Said, get it out before he makes the next set of assignments. And that's really her attitude toward life. She just does it, whatever needs to be done.
When Justice O'Connor and you were on the court together, you were called Justice O'Connor on more than one occasion each term, and advocates seldom seem to confuse Justice Scalia and Justice Breyer. Why do you suppose that was the case during your joint tenures?
I think the most likely to be confused would have been Justice Souter and Justice Breyer.
I know, because they look something alike.
Yeah.
And that could have confused people.
I think you were never called Justice Ginsburg, but
I might have been. I'm not sure, but there were some misstatements up there. And I remember one time it was one of my former law clerks who made the mistake. So, you know, he knew who was who. They get so nervous up there that anything can happen.
there was a former Solicitor General. There was a law professor.
I think it isn't a tense time for the advocates, I'm sure. And they get up there and are so concerned about everything that anything can slip out in terms of calling names.
Your comment about Justices Souter and Breyer reminds me of a story Justice Souter likes to tell. He was out to dinner one evening downtown, and someone came up to him and said, "Oh, Justice Breyer, I think you are the greatest justice on the court. I really admire your work. can you tell me who is your favorite justice on the court? And Justice Souter said, well, I think by far the greatest intellect on the court is David Souter.
You know the story about the National Association of Women Judges had a reception after my appointment, and they presented us with T-shirts. Sandra's read, "I'm Sandra, not Ruth." Mine, "I'm Ruth, not Sandra."
That's great.
I once saw an argument where the lawyer confused two women. I'm not sure. I think it was actually when you were on the court. So I think it might have been Justice Ginsburg and Justice Sotomayor who were confused. But and then 20 minutes later, the same lawyer confused two men on the court.
Oh, gosh.
And I think that the second was purposeful. I think he realized he had done it once, and darned if he wasn't going to do it again with gender neutrally.
Oh, that's funny.
But that's the difference that 3 makes, because we haven't been confused. 3 of us have not been confused.
I thought it had happened once, and I think it was you and I. But that is also understandable because we flank the 2 ends of the court, and I'm told that you can't always hear where the voices are coming from, so I'm giving them an excuse.
What were your biggest challenges in joining the court? And all of you have probably had different kinds of challenges, but Justice O'Connor, you being the trailblazer.
Well, trying to write opinions that not only deal with the issues, but in a way that is useful and will be long-lasting. And that's a challenge. It really is. Many of these issues are issues that are ones where the lower courts have been in total disagreement, and sometimes for a long time, and things that matter, that are important, or the court wouldn't have had to take them. And when you have to put down on paper permanently the tests that you're going to apply and see how it works, that's a challenge every single time. And you really want to do it well, and you won't know till many years have gone by how well you've succeeded. You can't tell instantly.
Mm-hmm.
For me, opinion writing wasn't new because I'd been on the D.C. Circuit for 13 years. But was new was the death penalty cases. I had no idea that the Supreme Court it deals with so many 11th hour applications for stays.
Yes.
And it was a whole new.
Justice Sotomayor?
It was walking into a continuously running conversation that you're a newcomer to. I can't say how many conferences my first year a justice would explain his and sometimes her position, and I thought their explanation would be coming out of left field. And it would take Justice Stevens or sometimes Justice Alito or Breyer, who would see my note of incredulity on my face, what are they talking about, to lean over and say, oh, this has to do with this picadillo they have about XYZ. That wasn't argued by the parties, and I certainly hadn't anticipated being part of the reasoning. And that went on frequently. And I remember the first time when Justice Kagan came in, when she leaned over and said, what are they talking about? and there was some sense of satisfaction that after a year I could actually explain something. Yeah. But it is, when you're working with the same 9 people, with the same other 8 people, the same 9 people are working together, it is a long-running conversation at times. And at moments, coming into the middle of it can feel just like that.
Yes.
It's a very interesting observation. I remember Justice Brennan once saying to me that he had been on the court for a couple of decades at that point, and that so the thing about serving so long is that you've seen all these cases before. The issues are very similar that come up year after year. So the ongoing conversation, that's a very astute observation. Justice Kagan, you're a veteran now after a term and a half, and are you still, are there still challenges for you adjusting, or are you, you've hit your stride?
Every day is a challenge. But, you know, for me, I had never been a judge before, and just figuring out the mechanics of the job. You know, I have these 4 clerks. What do I do with them? You know, what's the best process for drafting an opinion? When do I read the briefs? Do I read them the day before or the week before? So all those things, which I think most of my colleagues had just sort of figured out what processes worked for them, I was very much last year and continuing to sort of do trial and error and experiment a little bit and figure out what worked for me.
Right. As serving as a Solicitor General, did you find that helpful and useful?
Yeah, hugely helpful. You know, because you're just sort of looking at the court from a somewhat different vantage point, but really spending all your time thinking about those 9 people and what they're doing. So sometimes I think that the job doesn't really change at all, that as Solicitor General, my life was spent trying to persuade 9 people, and now it's just trying to persuade 8 people.
Yeah.
Justice O'Connor and Justice Ginsburg, you both served as the only female on the court during a period of time, and you both, I recall, expressed hope for another female appointee during those times. It may be obvious, and obviously it should be obvious given this conversation, but why is it so important to our country and to the court to have
Well, maybe you haven't noticed, but I think about 51 or 52% of the population are female. And I think they notice when their public bodies are dominated entirely by one sex. I think women care about that, and they should. So I really think that's part of the deal.
Yep. It is indeed. When you joined the court in 1981, the court heard 184 cases that term. It heard 82 cases last year.
Isn't that amazing? It just shows they're not working.
I was going to ask you, as they would say in Kentucky, do these young'uns have it easy?
They do. I mean, it was a devastating amount of work, I'll tell you, because you had to go through all the petitions for certiorari, and that was new to me. I couldn't do it quickly. I could after many years. You've seen them before. But that was hard, and then to have so many opinions to deal with was very challenging.
I would like everyone to know that I still work long into the night. I don't think the job is any easier. I do think one thing has been reduced substantially, and that is in the old days when they were hearing 150 cases, you would get these terribly fractured opinions where someone would announce the judgment of the court and an opinion in which Justice so-and-so joined part 1D and 2. I think with fewer cases, there's less of that kind of fracturing.
There would be, yeah.
I think that, yes, from external observation, I would say that the opinions are crisper, cleaner, and easier to understand these days. It's probably better for the court. There are several theories as to why the court is hearing fewer cases, everything from fewer conflicts among the circuits to differences, I guess my question is, are there mechanical reasons internal to the court as to why this may be the case as well?
I'd be interested to hear that too. I'm not sure why the number of cases the court is granting are fewer. I think the numbers of petitions are still high. I don't think
those
that's
have increased,
reduced.
actually. And that's probably
There's
one of the
a
reasons
few
I know
more.
that justices are working just as hard, because you review so many cert petitions, over 8,000 a year. And I didn't mean to suggest you weren't working hard.
No, I have to say that I'm not quite sure how you managed that number.
I'm not sure
in
either.
years before, because I know I'm at the max where I am.
Right.
I know because I've looked at many of the studies and the discussions about why the court is taking lesser numbers now. And I wasn't sure when I read the studies that I really adhered to any reason as being the reason. I think even being a part of it now, I don't think the court purposely.
There's no conscious
effort to suppress the number. I don't think we look at the number and say, we can't take more than X number this year, so we're going to turn this case down because it adds too much to our workload. I know that for myself, I can only speak for myself, that I'm very conscious about, is this a case with procedural vehicles or not? And a lot of those cases that I read from years before, the court wasn't even reaching the issue that they granted cert on because there were vehicle problems that they were addressing and resolving and never reaching the substantive questions.
But there is one contributor to it that's, it's not the whole part, but it is a large part, is that until, was it 1988? When you came on, Sandra, there were still many must-decide cases, many jurisdictional statements rather than cert petition, where the court was supposed to, the jurisdiction was mandatory. Now, for advocates, for civil rights advocates in those days, it was a great thing, because you could go to a 3-judge court for challenging a statute as unconstitutional, and then you could go directly to the Supreme Court on appeal, skipping over the Court of Appeals. But so that, I think, the end of the must-decides. I mean, nowadays we have some
that must be part of the reason. There has to be several reasons that the numbers have dropped. That could be.
Well, it's part of it.
The current court appears to be more active in questioning from the bench than some earlier courts. There have been statistics that have been gathered in that regard. Is this just a different manner of judging? Is it personality-driven? Is there are the court's conferences, and I know you don't disclose what goes on inside the court's conferences, but does that add to the initiative to ask more questions from the bench and communicate with each other through questions from the bench? Or how would you explain the increase in the number of questions from the bench during oral argument?
Maybe women ask more questions. I don't know. What do you think?
I think it was on the rise even before there were 3 female justices.
I think it was too.
Well, it's the women and also the law professors.
Law professors, that's got to be it.
And that, it is very much a matter of individual style. I know when I was a new justice, Justice Blackmun came to see me and he said, Ruth, I want to give you some advice. It was given to me by Justice Black when I was a new justice. And he said, don't ask many questions, because if you don't ask many questions, you won't ask many foolish ones.
That's good advice.
Well,
what did you say?
I was not intimidated by that. And I think he was disappointed that I didn't take his advice.
We hear a phrase now that Washington is broken, and the observation is usually made about the legislative process, which appears to be at an impasse on many difficult issues. Budgets, even the budget is difficult to pass. Compromise appears more difficult. But that's a phrase really that it's never been used, to my knowledge, to apply to the judiciary. Why do you think the judiciary works relatively well? Is it by comparison to the other branches? Is it because you make decisions and not avoid them or kick them down the road? Or how would you explain the differences?
Well, one thing is we don't set our own agenda, and we don't have an initiating role. We are a totally reactive institution. we can't say, oh, this is the year that we're going to take care of the Fourth Amendment. We react to the petitions for review. So I think that's part of it, that we don't have a platform, we don't have an agenda to put forward. We are reacting to the petitions that people bring to the court.
I think we have to explain our reasons, and not just in a cursory fashion. Mm-hmm. And I think, Justice O'Connor, you wrote something about this a while back, where you said that almost every judge has an internal need or drive for consistency of some sort. Mm-hmm. You don't want to be arbitrary yourself.
Right.
And I think that makes us, in some ways, less reactive to sort of what's happening outside of our courtroom, mm-hmm. and to the legal issues that we're watching develop and participating mm-hmm. in considering.
Right.
What would you say the attributes are of a good judge, good justice? What advice would you give the young women and young men in the audience who might aspire to be a judge or justice someday?
Well, you have to think clearly, be reasonable and rational, write well, and just have a sense of fairness, I think. All of those qualities come in, and others as well. But it's a challenging job to be an appellate court judge and to try to explain well your reasons for everything you do. That is very challenging.
I asked Justice O'Connor if she had a role model, and she rightly pointed out, I think, in her own way, that she was a trailblazer, probably didn't follow the path of many, but I'll ask each of the other justices, who was your role model, and couple that with the question about how important it is to young women today to see you on the bench at the Supreme Court.
Well, Sandra and I come from the era when women were simply not judges, and very few of them were lawyers. I think when we went to law school, maybe 2-3% of the law students were women.
If that.
And we never saw a woman teacher. There was no Title VII, so employers were upfront saying that they really were not interested in hiring a woman. I mean, for us, the change has been enormous.
Yes, total.
In our lifetime.
Total change. I couldn't get a job when I got out of law school. Mm-hmm.
Well, we're all the better that you're now serving, and I mentioned this to you before, Justice Ginsburg. One of my best friends had you for a course in law school at Columbia. Said you were the best professor he ever had. So,
good.
Well, he was not in any of Justice Kagan's classes. So.
That's right. I didn't know anybody who went to Harvard, so I don't have friends. Well, it's so important. I think we'd all agree to see you on the bench, and you're an inspiration to not just to my daughter, but to my sons. I think the way you all go about your work is wonderful for the country. I'll conclude with a couple of other questions with Justice O'Connor. You have said your work with civic education, which you've now dedicated your years to, is the most important work of your life. I tried to debate you on that point.
I know.
At some point, but
there's been so much discussion in public venues about the judicial branch of government and activist judges. I used to think it was a judge who'd get up and go to work in the morning, but people have other ideas about activist judges. Much criticism. And it seemed to me that it was primarily a lack of understanding by many people about the role of the judicial branch. Of course they have to decide questions we don't like and wish weren't there, but it's not the judges who are bringing these things. And I really thought we needed to enhance the education of young people about how our government works. And the reason we got public schools initially in this country was with the argument that we had to teach young people how our government worked, about the system the framers developed and how it all worked and how people can interact within that system. And we were finding that barely 1/3 of Americans, including young people, could name the 3 branches of government, much less say what they do. The percentages of people who understand how the system works are so small. And so there's a real job to do. And we had a conference at Georgetown Law School and had wonderful people participate and talk about the problem. And it really did boil down, I think, to lack of education. So I got some people together and we started a website called iCivics.org and geared it to young people, to middle schoolers primarily, and did it with games because young people that age spend about 40 hours a week in front of a screen, whether it's television and or computer. And I only needed about an hour a week. That would be fine with me. So we developed some games with the help of some wonderful teachers who knew what principles needed to be included in something for that age group on the subject. And we've succeeded in producing a fabulous website. And I've spent a lot of time trying to get it in use. And we have chair people in all 50 states now. And we're getting about 5 million hits a day. That's not nearly enough, but it's a good start. And it's taking effect, and it is very effective.
That's wonderful. We're going to devote a lot of time here at the museum to civic education and outreach programs, and would love to work with you on that.
Good.
I have to ask a First Amendment question. You walk in this building, and the tablet on the front of the building is the First Amendment of our Constitution. We had a visitor here visiting with a friend of mine. He was from Russia, and he walked through the building and observed some of the exhibits here. And he said, well, you know, we have free speech and free press in Russia, too. But the difference is here, you're free after you speak. And it was a rather profound and humorous observation. Indeed. But there is a very substantial reason for that. And it's an independent judiciary that protects us,
That's right.
our First Amendment rights and our Bill of Rights, and distinguishes us from others. Do any of you have observations about the importance of that in our system of government?
It's tremendously important, and it's very fragile. And it was from the very beginning. There's a cartoon after the Revolutionary War, which shows some Tories being hauled off, and the caption is freedom of speech, or liberty of speech, for those who speak the speech of liberty. Mm-hmm. And it really is rather recent times. It wasn't until the last century that the First Amendment became a major item on the Supreme Court's docket. And in the beginning, the performance was nothing to rave about. It was the first World War I cases, when people were being charged with offenses that had to related to what they were saying about the draft, about the country's political situation. So I think it's in part due to some pretty great justices like Holmes and Brandeis, starting out as dissenters. All those old dissents are today the law of the land. Mm-hmm.
Well, I think we would all agree that the country is far better off, that all of you have served and are serving on the Supreme Court of the United States. We're very grateful and honored that you'd be with us here this evening in celebration of Justice O'Connor's 30th anniversary for appointment to the Supreme Court. Thank you for being here. And Greg, would you like to
Thanks, Jim. Please
closing remarks?
join me in thanking Justices O'Connor, Ginsburg, Sotomayor, and Kagan.
Thank you. That's lovely.
We also want to thank Jim Duff and the Freedom Forum for making this partnership this evening into a wonderful event. We look forward to partnering together again. I also want to thank those of you that are members of the Supreme Court Historical Society for your support that helps put on programs like this, and to tell those of you that aren't that it's not too late. There's plenty of time. SupremeCourtHistory.org. There is a reception in the atrium, and with that, we are adjourned.